gave me two of these. You gave me two.
Let's see, do we have Ms. Winchester up first?
Your Honor, may it please the Court, Claudia Bolgan for the mother in the Essex case. We will be splitting our time. Attorney Winchester will be after me with regard to the issues of the statutory basis for a right to counsel.
Okay, and so you have 7.5 minutes?
Correct, Your Honor.
Okay, so fine, go ahead.
Thank you, Your Honor. The petitioners come before this Court today asking this Court to hold that when an indigent parent is involved in a CHINS proceeding where custody loss to DSS is at issue, that parent has a due process right to be appointed counsel. That right flows from the fundamental right of a parent to the care and custody of their child, the fundamental right of a parent protected by the due process provisions of the state and federal constitution to make those decisions.
I suppose that the Attorney General would argue that your custody isn't an issue.
They would, but that would be incorrect. Custody is an issue.
Okay. Does the statute use the word custody?
The statute doesn't, but the same instances of custody are lost when a parent loses a child to DSS in a CHINS as in a CNP. The only difference...
Do we have, I might well agree with you, but do we have to give some weight to the fact that the legislature used different words? What do we do with the fact that they didn't use the word custody and they could have?
That is immaterial. It's immaterial because the substance of what is going on here is the custody loss.
So we ignore the legislative language?
Well, Attorney Winchester has a detailed study of the statute that she will be happy to answer Your Honor's question during her time.
Okay. Well, then another question. The statute, I think it's 29, that talks about appointment of counsel for it enumerates all these statutes in which parents have a right to counsel. Wouldn't it have been quite easy for the legislature to have included this section?
What the legislature did is they included the general provision for any other proceeding involving child custody where DSS is a party. What the petitioners contend is that that does include CHINS.
That language is difficult to construe. You will concede it isn't readily apparent what that means.
True, but at the time that language...
If they wanted to make it clear that it applied in CHINS cases, they could have either just said CHINS or they could have referenced, I think it's Section 39.
They could, Your Honor, and we do have a statutory interpretation argument, but as well as a due process argument.
I take it from a due process point, well, let me just back up. From a due process point of view, I assume that we look at this to determine whether what happens in certain cases in a CHINS proceeding is sufficiently different, right? And so from a due process concern, let's say you assume for the present time that they are not sufficiently different.
That's
from a due process point of view. Then it seems to me that you have to reach the next question, which is, in such cases, was the legislature required to provide for counsel fees, correct? And your answer to that question is?
The legislature is required to provide counsel. Why? Because in a CHINS case, Your Honor.
No. In a, let's say we've now got to the point and say we are using the term for due process purposes, custody. We're not dividing, the legislature has divided the two, but we're just going to use custody. Is the legislature required to provide parents' counsel? It's a civil proceeding?
Yes.
And why? Is it from a constitutional point of view?
From a constitutional point of view, this Court has not distinguished between grandparent visitation that might only tangentially impact.
No. I don't think, maybe I'm not asking the question in a way that you can hear it. In what circumstances is the state required to provide counsel?
When custody is lost to the state. When custody of a child is lost to the state.
That might be in almost every case.
And what authority is there for that proposition?
I would start with JKB. The JKB case was the first case that this Court found that when a parent is embroiled in a contested proceeding with the state, that due process demands that they be provided with a right to counsel, that they will not be meaningfully found to participate in that proceeding unless they are appointed counsel. And the case law has progressed from that on to the present day.
How many? What are the numbers? Do we have an idea, or what's the percentage of cases where the children are actually removed?
In a Chin's proceeding, Your
Yeah.
Honor? I did cite in my brief to the trial court, juvenile court statistics, which said that in, for example, fiscal year 2006, there were 577 children in DSS custody by virtue of Chin's petition.
But my question is, how do you know at the outset whether there's going to be a transfer of custody?
Your Honor,
you argue a lot that you'd only need, that your position is that it only applies when there's a transfer of custody, not when there are less serious steps. But how does one know at the beginning what the ultimate outcome is going to be?
in a Chin's case, there are two parts to the proceeding. There's the adjudicatory part of the proceeding where the determination of the facts, whether a child is indeed in need of services, is made. And then there's the dispositional part of the hearing. This court in Angela held that those two are separate. And a good point could be made that with regard to the adjudicative part of the hearing, the parent's participation may not rise to the level of requiring appointed counsel, but it's in the disposition, Your Honor, where...
But that doesn't make terribly good sense, it seems to me, because it's so important what the adjudication is. If the parent could succeed in having the child not adjudicated at Chin's, then you don't have to worry about what the disposition is.
Agreed, Your Honor. However, that the disposition over time can change. For example, in the initial adjudicative hearing, no one may be advocating for the child going to DSS custody. At that point, the right to counsel may not attach. The issue of DSS custody may come up later in the dispositional hearings and the extension hearings that are provided every 6 months under the statute.
Do I hear you say that the attorney should be provided only in the dispositional stage?
If there is not at the outset a determination that loss of custody is a potential...
Do you make that clear in your brief?
In the reply brief, we have focused, in response to the AG's argument, more on the dispositional side, that it's in the disposition of these Chin's cases where the issue of custody loss really comes into play, not in the adjudicative portion of it.
So there'd be about 500, 600 cases, you think, based on the data you have, and the state would pay for the lawyers?
The state...
Obviously.
Yes. The problem here is that the population served by Chin's, Your Honor, is an unsophisticated, indigent by and large population. Both of the judges in the Worcester case and the Essex case seemed to say to the parent, if you could pay for a lawyer, I'd be happy to have your lawyer here. That's the problem. There's obviously a place for a parent and perhaps a place for a parent's counsel.
The number is 500 to 600, as Justice Graney said, if we take your proposition that it's only the dispositional stage. But what about if there is a necessity for a lawyer at the adjudication stage? Then do you have any idea what the numbers would be?
That would be higher.
Well, obviously, but
that would be
you have
higher.
any idea what the
but
number?
Again, a judge will know relatively soon in the process whether disposition to DSS is something that he or she would consider, and that's at the point at which we suggest that the right to counsel would attach to have the parent be able to effectively present whatever information
But how can you
and
stop
argument.
then the right to counsel attaches and you appoint counsel and you go back and start at the beginning? No.
Well, it's a two-part process, Your Honor.
No, I know. So you're saying that it's only at the disposition stage.
I would argue that it would be most effective at the disposition stage when, at that point, the issue of DSS custody comes to the fore, when a judge must make the determination whether the child stays with the parent and under what conditions that happens.
What percentage of these cases are instituted by parents?
Indeed, and we are not advocating...
No, is it like all of them, or...
No.
Most from the DSS.
DSS can file, as happened in the Worcester case, a school truant officer can file, as happened in my case, a police officer can file. Indeed, many Chin's cases are started by parents. They're started by parents who actually probably have no idea that once starting it, DSS custody loss is a possibility.
You're not seeking counsel in those cases, correct?
I'm not seeking counsel for the prosecution of a CHINS petition. However, if at some point in a stubborn child brought by a parent process, a judge looks at the parent and says, listen, I'm thinking about removing your child to DSS custody, at that point, I would argue a right to counsel attaches.
Thank you.
Thank you.
Ms. Winchester?
Good morning, Margaret Winchester. Judge, if I may speak to the question that you asked earlier regarding custody and the legislature not using the term custody in the CHINS proceeding. The legislature used different words in different proceedings in the entire child welfare statute. In the CHINS proceeding, they talked regarding a commitment to the Department of Social Services. In a 23C proceeding, they in fact talked about responsibility being granted to the Department of Social Services. In all of those cases, the result of their language is in reality giving custody to the department, in that the department loses all of the same incidents of custody over their child. The parent
The parent.
does.
The parent loses custody over their child.
You
I'm
said the
sorry.
department
I'm
loses.
sorry. The department has custody, and the parent loses responsibility. They
Well,
lose.
there are some, I don't know how you would, but there are some differences. Marriage and extraordinary medical care, but you're saying that for all practical purposes, the child is in the in the custody of the department.
And in fact, they only have, in a CHINS proceeding, they only have the ability regarding extraordinary medical care because under the department's regulations, they delegate that back. The department has it in under 1102.
So the department is delegated back, not because they
Yes,
need
the
not.
department delegates it back, not
They
the
need not
courts.
do that.
No,
Okay.
but they in fact delegate it back under their regulations.
Could I just ask, one question. There's an argument that the DSS isn't a party to these cases.
Yes.
When a judge is contemplating in the dispositional phase of giving custody or to DSS, does DSS become a party, or how does that work?
I think it is very similar to the 23C proceeding when a judge contemplates giving party in the probate custody in the probate court. Many times the department is given custody by the court without the department in the courtroom and without anybody present during that proceeding. So our suggestion is not that they are a party in the sense that they file motions to gain custody in the CHINS proceeding, but that in fact they are a party just as they are in the 23C proceeding when the probate court on a sua sponte order gives them custody, which, as this court has recognized in those 23C proceedings, in fact, the parents have the right to the same review, the same hearings as does a child in a care and protection proceeding. So that the parents, in fact, in a CHINS proceeding who are losing the same incidence of custody should, in fact, be entitled to be represented at
Would the
those
parent's
hearings.
interest be served by the attorney for the child most of the time? Not all of the time, of course, but most of it.
Their parents' interest in the child's may be the same in some proceedings, but it does not necessarily mean that their interests are served by child's counsel. As we all know, child's counsel in these proceedings, in fact, is to represent their child.
Are you arguing, by the way, that the parents who would not be a party to this proceeding unless they initiated the CHINS petition, right? Our parents should need to be made parties?
Yes, we are arguing that at the time that custody is going to be granted to the Department of Social Services and that the parents are losing custody, that the parents would have a right to intervene automatically in these proceedings and an ability to be heard. As evidence in the Worcester case and in both cases, in fact, the court said that they would hear from the parents, but not, in fact, allow them an intervention status, not allow them to present
Well, what about a
evidence.
right to intervene that's consistent with the rule, which is that if the interests of that party are not already being served by the interests of another party?
Well, in fact, the interest of the parent in the Chin's case is not being served by the interest of the other party. They're not being served by the interest of the child. They're not being served by the interest of a petitioner if it is the school, the police, or the Department of Social Services.
But aren't there at least some times, if not many times, when the interest of the child and the parent will be the same?
Their interests may be the same initially. Their interests also may change over time. As we all know, there are many of these Chin's cases that are stubborn child at home where the parent is seeking assistance from the court.
Well,
They're
if that's the
seeking
case, then the
services.
parent is a party, and because then the parent initiated the proceeding and is a party. But I mean, if you're trying to reduce the number of times, aren't there some of these 500, 600 cases where the interests of the two people will be the same?
But your point is a fairly simple one, isn't it? That they may have congruent interests sometime, they may not. But at the time, you know, the stubborn child, to take that as an example, the state begins to say, well, you know, you've kind of been a failure, Mrs. Jones, so we're going to move this kid into DSS. Their interests split and become adverse.
Absolutely.
Because Mrs. Jones says, I never wanted that. I just wanted you to knock some sense into his head so he'd go to school and all that kind of stuff. Right?
And that they want
Well, but
assistance.
if you're advocating that you don't need to have the, or at least as I understood, your co-counsel was arguing that you don't have to appoint the attorney at the outset, only in the disposition stage, then couldn't the judge just stop when he or she sees the proceedings getting to the point where the interests of the two diverge and say, okay, now I think a parent should have an attorney?
Well, absolutely, because it is not until the dispositional stage, in fact, that the court can grant custody to the department, or can grant custody to the department and commit the child to the department, despite the fact that that's not what happened in the Worcester case. But under the statute, the court, in fact, cannot grant custody or cannot commit the child to the Department of Social Service until that dispositional stage. So there are normally two proceedings within the Chins. There is a determination as to whether or not the child is in need of service. Are they a runaway or a stubborn child? And then there is the dispositional stage. And it's at that stage, in fact, that counsel, in fact, could be appointed if there was going to be that transfer of custody.
So are you arguing, as I understood Ms. Winchester to argue, that you're only seeking the appointment of counsel at the disposition stage?
Yes, because that is the only time in which a determination of custody and a change in custody can be made to the Department of Social Services.
Well, go ahead.
Now, was that made clear in your brief? I'm just afraid I didn't read the briefs that way, but maybe I misunderstood.
I believe it is clearer in the reply brief when we address that issue regarding the two stages, because it is not until our briefs suggest that custody or that appointment of counsel should be made at the time the court is considering a transfer of custody. And they cannot make that consideration of a transfer of custody until the dispositional stage by statute.
Do you think Rule 24 if Rule 24 were used as the vehicle here, would that, which would be a case-by-case determination, would that be acceptable to you? Or are you saying that in every case, I mean, this is sort of going to Justice Cowan's point, that there may be, on a particular factual situation, a judge may say, right now, it looks to me that the interests of the child and the interests of the parent are totally aligned, so the child's lawyer can represent both.
No,
And
we are
so I'm not going to allow an intervention. Or are you saying that by way of statute or constitutionally, there needs to be, regardless of that, in every case there needs to be a separate lawyer?
We are saying that in every case in which they're considering a transfer of custody, there in fact would need to be a separate
Presumably,
lawyer.
a parent in this situation at the dispositional stage, if unrepresented, wouldn't be smart enough to know how to intervene. I mean, that
That's
requires a
correct.
motion, and, you know, it's fairly technical, and how in the name of God are they going to do that?
They would not know how to
Without a
intervene at
lawyer.
that point without
So then we're
the
back to the
appointment of
beginning,
counsel.
where there'd really need to be an attorney appointed at the beginning.
No, the attorney could be
Oh, the judge would just do it
appointed.
automatically
The judge
in the
could do it
disposition
automatically
stage.
at the dispositional stage, just as they do in the care and protection or 23C proceedings.
Ms.
And could
Winchester,
you clarify one thing for me? If a parent could afford a lawyer, they wouldn't have any problem being represented by counsel?
If they could afford a lawyer, they would not have any problem. They would still, without
have
the,
to-
without the right to, without a right to intervene in these cases, they would have a problem with fully being heard in these proceedings,
In
however.
these two cases, it so happens that the judges said, you know, if you can have your own lawyer, I'll be glad to hear from the lawyer.
Well, they said that they would be glad to hear, but they would control the role that counsel played in that proceeding. So they did not, in fact, give them party status
Yeah,
to
so
be able
this
to
is
object.
not a case where it's being distinguished between people who can afford lawyers and people who can't, because the judges are saying, maybe properly, look, if you get a lawyer, because you can afford it, he or she is, you know, just going to have a very limited role. Right?
That's what the court has said in these cases, yes.
Ms. Winchester, could you help me, because it's not entirely clear to me, and I understand that is the basis of the claim that, of the right to counsel, that in light of the fact that the legislature has deemed the liberty interests at play in what it terms a custody termination of parental rights case, in light of the fact that the legislature has determined that it would provide counsel for parents, that where, for all intents and purposes, and let's just say we agree with you for those, that what's at play here, albeit it might be for 6 months, it's not permanent termination, that the legislature has an obligation to provide a right to counsel. Or is your claim that regardless of whatever the legislature had decided to do in the parental termination cases, where you have this kind of infringement of a parent's fundamental liberty interests in the raising of his or her child, the state must provide counsel?
It is really the parent's fundamental liberty interest in their right to their child, as this court has also held in Laurie, which is a 23C proceeding, which is a case of a dispute between two parents, where the state, in fact, has...
So viewed one way, if that is your claim, one need not engage in a comparison between what happened in a more classic custody termination or change or temporary handing over. You're simply saying, look at what happens in these cases. And under our well-established case law, given the liberty interests of the parents involved, the state has to provide an attorney. Am I correct?
Yes, that's correct. It's the same liberty interest regardless of what the nature of the proceeding is.
Okay. Thank you, Ms. Winchester.
Thank you.
Mr. Hammond?
Thank you, Your Honor. Daniel Hammond, Assistant Attorney General for the Attorney General.
I have one question before you begin. I understand that initially if the judge transfers custody to whatever you commits the child to DSS, it's for 6 months, and then thereafter 6-month renewals or reviews. Are the review proceedings somewhat perfunctory?
Well, not perfunctory. And this court actually addressed the 6-month review function in the Angela case and made clear that the burden of proof remains on the petitioner or a proxy for the petitioner. In Angela, the
yeah, well, it's
petitioner
my
was no longer
memory
a
of the
party to
Angela
case.
case, I think, that prompts me to ask the question, because
Yes, Your Honor.
what I'm the feeling that I got from what I remember of the Angela case reading the briefs is that maybe at some of these 6-month continuations that not a great deal of time is spent by anybody on them. Is that fair to say, or am I getting the wrong impression?
I think that was probably true to some extent pre-Angela. I think Angela actually corrected that flaw. I think a number of juvenile courts treated the 6-month review session as kind of a pulse taking to see how the placement was working out and whether there was any need to substantially change it.
So we're talking temporary transfers here. We're not talking of anything that becomes a permanent.
Well, that's correct.
But you're talking lengthy.
Well,
You're talking 6 months.
6
Since
months, so
this
that may be
petition-
extended.
Minimum.
Correct. They can go 6 months at a bite.
During which period of time, what is the difference between what is happening in a so-called CHINS proceeding as opposed to where the department is seeking to remove the child from the home, which may also be temporary, correct? In other words,
Yes.
CMP.
In a CMP.
Well, a CMP can be temporary, except one clear distinction at the outset is a CHINS is statutorily limited to the 6-month period.
no, I understand,
whereas
but I'm looking at it from the point of view of the parent. A CNP can
Yes.
be for a very short period of time, but you get a right to counsel. It can be for 6 months, correct?
Yes,
you
it
get a
can.
right to counsel. So I'm a parent and I'm going through a CNP 6 months, or I'm going through a CHINS. From the parent's point of view, what are the differences?
Well, the difference is, the key difference, I guess, would be the incidence of control that actually passed to the department.
Yes.
And
And
a
so
char-
we've heard about the emergency medical, and that's been a delegation back, but the department doesn't have to do that, right?
No, it doesn't. But as a functional matter,
It
the
has.
department in its regulations distinguish
But even
between...
in CNPs, when it's that type of a medical decision, the department usually goes to court.
That's correct.
Doesn't have to, but does.
That's correct.
And so what are the other differences?
Well, certainly the adjudication itself hinges not on a finding of parental fitness, but
No.
hinges entirely
I'm
on...
asking from the parent's point of view. I've got a child.
Yes.
Right? And forget why the state tells me it's going to take my child away from me. From my point of view, what is the difference in terms of how I can, my relationship with my child, if the state chooses to go in through a CHINS door or a CNP door?
Well, again, it's that it's not a complete loss of all of the incidents of custody.
Neither is the CNP.
Well, in most cases it is, because...
Well, tell me in which way you don't have a
Well, most
complete loss.
CMPs ripen into adoptions.
Well, some do, some don't.
Well, some do.
Not necessarily.
But a lot of them
so,
do.
So you say it's not a complete loss. Tell me in what way it's not. It's Tuesday morning, and my child is not being rushed to the emergency room. And the state has control of my child under the CNP as opposed to a CHINS. What's the difference between what I as a mother can do on Tuesday morning?
Well, as a functional matter, there's not much of a difference on a day-to-day
Is
basis.
there any difference?
Well, there is the finite aspect of a
It's not
CHINS
finite if it
adjudication.
can be renewed.
Well, but it can only be renewed in 6-month bites.
And
where-
CNPs are not necessarily finite. So
True, but the party that seeks a review and redetermination under a CNP must initiate that review and bears at least a prima facie burden of proof to show that something has changed. That's not true in a CHINS case. In a CHINS case, the petitioner has to, at every 6-month review, has to come forward and show evidence, carry the burden of proof that the
I
adjudication
understand
should
that. I'm
be
just saying
extended.
from a functional, because what we're looking at is the liberty interest. And, you know, when we talk about other fundamental liberty interests, we really don't distinguish as a practical matter whether in some cases you lose your liberty interest for 1 day or for 10. We really don't. We look at what the functional liberty interest is. Are you deprived of your liberty in some way that you might be incarcerated? And I don't think the state has heard to argue that, well, if it's only for 4 days, and at the end of 4 days it can be up for review. I mean, you would look at the fundamental liberty. Isn't that what we have to do here?
Well, yes, but I think another analogy that is perhaps more apt is to compare the CHINS context to the juvenile delinquency adjudication context, where also a child can be removed from the home for a fixed finite period of time, committed to the Department of Youth Services, and that has not been deemed to be an impermissible infringement upon the liberty interest
Yes,
of the parent.
but the child has done something that is, in any other word, a crime. And there's been an adjudication, and somebody has found that the child did that beyond a reasonable doubt. I mean, it's really different.
The CHINS statute, the CHINS statute itself is sort of a hybrid, which grew out of the juvenile delinquency statute. Initially, the proscribed behaviors in the CHINS statute were treated as criminal matters in the Commonwealth. And in
Are they still treated as such in some other states?
I believe the Chins model is fairly pervasive now. I think in some states these behaviors continue to be treated criminally. Massachusetts, I believe, was kind of in the vanguard of creating this hybrid between.
Early on.
I'm sorry?
Early on, truancy is not stealing.
Correct.
Yeah,
I think
and Massachusetts is.
Right. Massachusetts was one of the first states to try to carve out this hybrid, which is not, as we argue, a loss of full custody, nor is it
I know, Mr. Hammond, and I really, if you've given me the best argument, when you keep talking about a loss of full custody, other than, and I'm not suggesting it's not important, but other than the 6-month incremental reviews, and that's why I frankly pressed both Ms. Winchester and Ms. Bolgen, which is to say, their claim is that in light of what the state does in a CNP, which might be for a short period of time, they claim that there's a constitutional right to counsel for the parent. Mm-hmm. So if that's as opposed to the state decided for whatever reason that it wanted to give, the state can provide a right to counsel in a whole variety of situations that are not constitutionally compelled.
Yes.
But once you make that claim, and assuming that we agree with them, and I'm not suggesting that I do, then when you have what is, for all intents and purposes, the same outcome for the person whose liberty interest has been recognized in proceeding A seems to me anomalous if it's not recognized in proceeding B. There may be some outer parameters there. In other words, if the CMP was only temporary and didn't ripen into a permanent termination, who knows where you could do it. But that seems to me the crux of the argument. And so is it the Attorney General's position that whatever counsel is provided in a CNP proceeding is only statutorily based with no constitutional requirement underpinning?
Well, the Supreme Court addressed this most recently in the Lassiter case, where they said that it would be a case-by-case analysis
No, I
as to
understand.
whether. So I think that is the outer parameter on the constitutional question. It's never really needed to be addressed here because the legislature did provide it as a statutory right.
But you understand the reason for my question, which is if we say that the provision by the legislature in the CNP is constitutionally, and then you can choose the word, compelled or informed or required, then you look to what the relationship is here between the state and the parent.
I do see the question you're asking. I think a distinction can be drawn whereby the Attorney General would concede that as a constitutional matter, a parent facing a loss of custody, and we do maintain that there is a bright line distinction there, would be constitutionally entitled to the provision of counsel.
Wait, do I hear you saying that you would agree with the petitioners that in the dispositional stage, if the issue is custody or commitment to the department, an attorney should be provided?
No, because, again, I don't want to blur custody and commitment. I think those are two different concepts.
Well, I understand the legislature.
And I think one thing that illustrates that point is Chapter 29B, which is the permanency statute, which requires within a year of a child being removed from the home, the department must proffer a permanency plan, which will be reviewed by the court. And in those proceedings, by statute, the parents are, including parents of Chin's children, are entitled to counsel as a matter of right.
Okay,
Mr. Hammond?
Can I just finish? Well, what is the state's objection? If we were to limit, I reread the gray brief of the petitioners, and I see that at the end they sort of segue into only appointing counsel when commitment or custody, if you will, whatever it is transferred to the department. What is the state's objection to that? Is it A, that that's contrary to the statute, and B, too expensive? Is that essentially the argument?
Well, certainly that it's contrary to
why do you object?
Well,
What's the harm?
I think that function is filled by giving counsel as a matter of right at this 29B hearing, which comes, as I said, no later than a year after the initial removal from the
A
home.
year is a long timeline
Well,
of the child.
The CHINS statute, was conceived by the legislature as this sort of hybrid vehicle to deliver services on an expedited, it was almost an intervention, get services to a child at risk, do it expeditiously, and then closely monitor the situation as it develops thereafter.
But 600 a year, I mean, 600 are in the commitment of the department, so it isn't just getting services, it's taking them, at least 600 of them away from the parents. What is the objection? I'm saying, why is the state against giving the parents a lawyer?
Well, again, I mean, the expense is part of it, but it's not.
The short answer is you don't think it's required.
Well, I
Yes,
asked
Your Honor.
that. I said, your answer is one, that the statute doesn't require it, and two, it's too expensive. I asked that about 2 minutes ago.
Yes, and I would agree with both of those responses.
So that's your answer.
Not necessarily
Okay.
in that order. I believe that, again, the Attorney General reads there as being a distinction between the incidents of custody lost in a CHINS proceeding.
So as I understand this procedure is the CHINS is for 6 months, but if it's going to evolve in a year into a permanency thing, then at that point the parents get a lawyer.
That's correct, Your Honor. And the reason for that, it's not because an actual custody interruption can occur in the CHINS case. It's because if after a year the child has not been returned to the home, the legislature has instructed the parties to reconvene and start to think long-term. A CHINS proceeding is very much a short-term, quick fix, get services to the child at risk as quickly as possible mechanism. If after a year the child has not returned home and is deemed that by the juvenile court not to be able to return home, that's where a bigger, longer-term, bigger picture question is.
What section is that, please?
29, doesn't 29B also apply to 23C proceedings, or not?
Yes, it does, Your Honor.
Yeah.
But, I'm sorry?
That's all right. Justice Island has.
Well, I wonder if we couldn't boil this down to, for the parent who's got a CHINS case, whatever the terminology is, whether it's commitment, change of custody, or whatever, the kid isn't there. And then you have a care and protection case, their kid isn't there. Either way, whatever label or terminology you use, shouldn't parents have representation when their kid won't be there?
Well, I certainly
I
understand.
would want somebody to represent me if the state was going to remove my child, and whether they called it custody, commitment.
Well, I certainly understand from a parent's standpoint why the two look almost indistinguishable. But from the state's standpoint, they are very different concepts. One does not,
Because of the temporariness, right?
because of the temporariness.
But don't we require don't they get a hearing, and aren't they entitled to counsel for a 72-hour hearing if the kids
Yes.
are being taken away temporarily?
Yes.
Yes, in a care and protection context, yes, they are.
Procedurally, let me just understand this. In a CHINS case, if the child contests the allegations, they've got a right to a jury. They have right to counsel, of course, in a CHINS
Yes,
case.
they do.
They have a right to a jury trial.
Yes, they do.
And what is the standard of proof at that?
At the initial adjudication, it is beyond a reasonable doubt. On the 6-month review, it changes to preponderance
And the
of
focus
evidence.
is on the child's conduct.
Focuses exclusively on the child's conduct, yes.
But you're getting services to a child, quote, at risk, because there's an
Well, that's
assumption.
the dispositional part of it. But the focus is on whether the child's a stubborn child, a runaway, truant. That's the focus of the adjudication.
That's the focus of the adjudication, exactly. And as to the disposition, then the focus becomes how best to curb that behavior and in what setting to do that.
And the parent at that stage has no opportunity to be heard or to be represented by counsel.
Well, as the cases below illustrate, parents are often allowed to and even encouraged to participate, but they are not granted intervention status. They're not treated as parties, nor does the
Excuse me,
statute
Mr.
provide for
Hammond,
that.
I'm more than a little confused. Chapter 119, Section 29B, at least my cursory reading of it, I don't see. Could you point me to where it says something about the attorney being appointed for the parent?
It's not a matter of statute, but juvenile court rules provide for that.
But so there's nothing in the statute, just as there's nothing in the statute here. Here being what we're talking about in the initial Chins proceeding.
Yes.
So there isn't anything in the statute.
That is correct. But
So
I think
juvenile court, so then by analogy, putting your argument, the juvenile court rules could provide for a parent to be represented by an attorney initially.
Or at the dispositional phase, anyway.
Or at the disposition
Yes, they certainly could. I would suggest that they don't, because the juvenile court conceives a bright line difference between the two.
So then your first answer to my question goes out the window, because I asked you, why is the state objecting? And you said two reasons. In answer to mine and Justice Graney's, the statute doesn't mandate it, and cost. But in 29B, it doesn't mandate it either, and you seem to have no objection to the fact that the juvenile court, in fact, you argue the juvenile court does appoint attorneys for parents in those proceedings.
Well, because conceptually, 29B proceedings contemplate a long-term disruption of custody.
But 6 months could be conceived of as long-term in a child-parent relationship. In fact, I think we said that in Angela.
Justice Cordy's questions, it seems to me, it brought out the fact that these Chins cases are a little bit more like the the juvenile delinquency cases than they are like the care and protection cases. The focus is the misconduct of the child, not of the unfitness of the parent. Whereas in the care and protection cases, the focus is the unfitness of the parent. That's why the parents get the lawyer.
Absolutely, Your Honor.
Well, but isn't it all one ball of wax? Because very often whatever the characteristics of the child of running away from the home or being truant from school, whatever you want to say, may be because of the way he or she is treated at home.
Correct.
But because of the unfitness of the parent, that may be the result. Isn't it
Well, then
all
a care
one
and protection proceeding can be brought, presumably.
Right, but isn't it all one ball of wax?
Not necessarily, Your
Maybe
Honor.
maybe not.
In fact, many Chins proceedings are initiated by the parent, him or herself, because it's the child's behavior that the parent, him or herself, cannot control the behaviors of the child and therefore seeks the provision of these services.
And the parent is required to attend the Chins proceedings, right?
That's correct. The parent is summoned.
They receive a summons from the court that they must attend?
That is correct.
And participate?
Yes, Your Honor.
Okay.
Thank you, Mr. Hammond.
Thank you, Your Honor.